Day, the Committee on Health, Land, Justice, and Culture is now called to order. Today is April 6, 2022. The time is 9:08 a.m. In compliance with the open government law, notice for this virtual public hearing were published in the Guam Daily Post on Wednesday, March 30th, and again on Monday, April 4th, 2022, and posted to the Government of Guam Public Notice Portal and live streamed, and this is live streamed via the Guam Legislature's YouTube channel. Notices were also disseminated via email to all senators and all main media broadcasting outlets. The Zoom meetings hosted by the legislature's AV staff and my committee staff, and I thank them for their assistance. The host will mute all Zoom participants until called upon by the chair. Individuals testifying shall first be recognized by the chair, and please state your name for record-keeping purposes before you begin your testimony. For this 9 o'clock hearing, there's one agenda item, Bill number 242-36 LS. I'd like to acknowledge the presence of my colleagues, beginning with my Vice Chair on Justice, Senator Talina Cruz Nelson, Senators Telaje, Joanne Brown, Senator Chris Duenas, Senator James Moylan, and Senator Mary Torres, the sponsor of the bill. And I'd like to ask Senator Torres to please introduce the bill.
Thank you, Speaker, and good morning to my colleagues. Bill number 242-36 LS is an act to add a new section 40110 to Chapter 40, Title 7, Guam Code Annotated, and to further add a new section 30.400 to Chapter 30 of Title 9, Guam Code Annotated, relative to the transfer or release of family violence victims from shared wireless plans. Madam Chair, when we think of family violence, we often refer to the explicit ways that abusers exercise power over their victims. Physical behavior, verbal attacks, or sexual abuse. But while these overt actions compel our attention, controlling a victim's ability to communicate is one of the most coercive tactics in the book and remains a hidden risk for survivors of domestic violence. For instance, under most shared phone plans, individuals cannot separate their phone number or be released from the plan without the account owner's permission. And this task can be difficult or dangerous when the perpetrator or family violence is the primary account holder. Abusers may use the shared account to access victims' call records or harvest their text messages or even track their location. This behavior, Madam Chair, is a sad symptom of a deeper problem, one that is plaguing the nation. According to the Centers for Disease Control and Prevention, about 1 in 4 women and nearly 1 in 10 men have experienced violence or stalking by an intimate partner during their lifetime. On our shores, family violence remains high on the list of crimes charged in court. And for the past 6 years, the Guam Police Department has logged over 1,000 domestic or family violence calls per year. So how does Bill 242 help? Well, if enacted, this measure would allow survivors to opt out of shared plans without fees or penalty or the account owner's permission. And under this bill, the opt-out request must be submitted in writing along with a valid police report, an order of protection, or a signed affidavit from a licensed medical provider, mental health care provider, social worker, or employee of the court. This measure also authorizes the court to issue an order requiring the transfer of billing authority to a petitioner who has been granted an order of protection and to release a petitioner from a shared website wireless plan, or shared wireless plan, At my request, the court reviewed this provision last July and submitted preliminary testimony supporting the intent and spirit of the proposed legislation. The administrator of the court, Christina Baird, also noted that other jurisdictions have enacted similar laws. These include Hawaii, California, Tennessee, Ohio, and New Jersey. Several other states are also considering legislation following the increase of domestic violence reports, particularly during this pandemic. In addition, US Senator Brian Schatz introduced a similar federal measure in the Senate last year. The bill, entitled the Safe Connections Act, was passed on March 17th and now heads to the US House of Representatives for consideration. While Bill 242 was drafted to align with that bill, should it make its way out of Congress, the passage of the federal measure is not necessary for this bill to stand. Ultimately, Madam Chair, these protections will do no good if those who need it remain unaware. That is why this bill also requires that a wireless telecommunications service provider make this information readily available to consumers on their website, in their stores, and in other forms of customer-facing communication. I realize this is a great deal to ask of our companies, and I am aware that most already go out of their way to work with their customers and treat these situations on a case-by-case basis, and I'm thankful for that. But worrying whether their phone company will help them is the last thing a survivor should have to think about. And so Bill 242 makes clear that no contract is sacred enough to continue abuse, and assures survivors that under the law, they can cut ties from their abuser without penalty, helping them to start over and feel safe again. Thank you, Madam Chair.
Thank you, Senator Torres. For the record, the committee requested feedback on this bill from the following: the Bureau of Women's Affairs, Guam Behavioral Health and Wellness Center, the Healing Hearts Crisis Center, the Office of the Attorney General, Guam Public Defender Service Corporation, the UOG Violence Against Women Prevention Program, UOG ISA Psychological Services Center, Catholic Social Services, Ali Shelter, UOG Social Work Student Alliance, Victims Advocates Reaching Out, or VERO, Familauan Rights, and telecommunications companies, including GTA, Docomo, and ITNE. And some of them are here today to testify. So we will now hear the testimony on the bill, beginning with Jane Flores, Director, Bureau of Women's Affairs.
Thank you very much, Madam Speaker. Honorable committee members, Sijus Masi, for the opportunity to testify in favor of Bill 24236 relative to the transfer or release of family violence victims from shared wireless plans. My name is Jane Flores. I am the Director of the Bureau of Women's Affairs for the Government of Guam, and I also am the Administrator of the Governor's Community Outreach Federal Programs Office, which runs all of our Office of Violence Against Women federal grants, our STOP and our SASP grants, and our Increasing Criminal Justice Responses grants. According to the Guam Police Department's Domestic Assault Response Team, or DART, in 2021, GPD responded to 1,226 cases of family violence. This is a 19% increase over the 1,030 cases reported to GPD in 2020. To say that we have a problem with family violence on our island is an understatement. The Guam Coalition Against Sexual Assault and Domestic Violence notes that our rates are among the highest in the nation. We know that victims of domestic or family violence are often financially at the mercy of the perpetrator, which is why Bill 24236 is so important. This piece of legislation allows documented victims of family violence to be released or transferred from a wireless plan that they may share with the perpetrator. This legislation is especially important when you consider that a shared phone plan is yet another way for a family violence perpetrator to be able to control their victim or victims. This is because, as was mentioned before, the account holder of the plan can monitor any and all phone calls or texts made by the persons under the plan. This ability to monitor the phone activity of a wireless plan can in effect prevent victims of family violence from reaching out for help. It can actually put a victim of family violence in more danger if the perpetrator accuses the victim of calling someone that the perpetrator may deem inappropriate for the victim to be communicating with, or reaching out for help. GPD reported that in 2021, 71%, an overwhelming majority of the reported cases of family violence victims were female. The Bureau of Women's Affairs considers this legislation an important component in helping to protect women from the scourge of family violence on our island. Sijus Masi for the opportunity to testify in favor of Bill 242-36. Thank you.
Thank you very much, Ms. Flores. Christine Tenorio, Attorney Tenorio.
Thank you, Madam Speaker, and Senator Torres and all senators here in the audience. And thank you for this opportunity to give me a chance to speak on behalf of this bill. As a former prosecutor and former family violence and head of sex crimes unit, I believe that this bill is very important for our victims, whether it is a charged case or not. And I do think that the separation of the provisions legally is going to help the victims here, because we have the victims who obtain civil orders of protection, as well as the victims who have criminal orders of protection. This bill does cover them and protect them under the way it's written. And so I do believe in the spirit of the bill, and I think that this is a very good idea. As an attorney, I do just have some questions that I think I'll just say for the record, and then we can maybe circle back to this later if I get the opportunity. I'm just reading this of how a judge would read the provisions, and I think the question would be, what if the order of protection ends? What does that do for the victim? Would they be able to go back into the shared wireless plan if they opt to do so? But the bigger question, which I think the prosecutors would face, is whether if you're not a charged victim of family violence, would this apply to you under the way it's written, because it's inserted in the family violence section. But this is definitely helpful, and this is going to help prosecutors, because in the way where as a prosecutor, when we try to get a hold of victims as far as the case, even though there's supposed to be a stay away order, we find that the defendants are actually holding the phone literally and keeping it from them, or if we call the number, the defendant will answer, therefore stopping us from communicating with these victims. So thank you to Senator Torres and all of the people who have all the other senators who've introduced this bill. This is going to be very helpful for the victims of our community. Thank you.
Thank you very much, Attorney Tenorio.
Madam Speaker, would Attorney Tenorio prefer that I address her question now while it's fresh?
We'll take questions. We'll do that in a minute. Yeah, let me just there's two more people to testify. First, the Attorney General's office, Shannon Taitino.
Good morning, Speaker Terlaje, senators of the Guam legislature. My name is Sharon Davis. I'm Chief Deputy here at the Office of the Attorney General. I'd like to thank all of you for the opportunity to present testimony on Bill 242. We are still reviewing this measure as well as other bills that are before this committee today, but wanted the committee to know that we support this bill, which will make it easier for victims of family violence to seek independence from an abuser while maintaining consistent phone service. The only area of concern we have is how a victim could receive this relief outside of the protective order process. As currently proposed, a victim who does not file a petition for protective order is required to produce documents showing abuse to telecommunications service providers in order to opt out of a shared wireless plan. A victim of family violence may be reluctant to share police reports or details of their abuse with a telecommunications service provider, even if the bill makes this information confidential. If the intention of Section 3 was to permit courts sitting in criminal jurisdiction to grant this type of relief, one suggestion could be to expand the authority of courts to grant victims of domestic violence control over their wireless service provider in Section 1 to include criminal actions brought pursuant to Title 7, Chapter 40, as well as criminal cases brought to Title 9, Chapter 30. Title VII is a civil procedure to obtain a protective order or restraining order. And Title IX, Chapter 30 is the family violence chapter. If the bill proceeds as proposed, we offer two additional suggestions. The first would be to allow certain individuals, such as an attorney or victim advocate, to submit the opt-out request to the wireless service provider, along with any required documentation. The second is that a declaration made under penalty of perjury may achieve the same purpose as a signed affidavit without additional barriers, such as a notary requirement. Thank you again for your time and consideration, and we'll submit this testimony to the committee.
Thank you very much, Attorney Taitano, Chief Deputy AG. We'll now hear from Sharon Davis. Ms. Davis? I'm sorry, Ms. Davis, we can't hear you yet.
Yep, just hit the unmute button. Thank you, everyone, for the opportunity for us to participate in this hearing. My name is Sharon Davis. I have been at GTA for about 15 years now, and I am the Vice President of Customer Experience here. So pretty familiar with these kinds of situations as they come, customers come to us. We will also be submitting, for the record, Dan Tydenko and I. GTA fully complies with all lawful U.S. processes, including court orders, subpoenas from enforcement agencies. And anytime we've received these court orders or protective orders, we've done everything required and possible to ensure the compliance and assistance of victims of domestic or any violence. We also participate in the Project Rise. And Project Rise was where we had gifted prepaid phones and SIMs as they were needed. So we made changes. I believe that, as it was explained to me yesterday, that, for example, this team was recycling phones. So maybe someone who needed the assistance for this month, the phone was retrieved, and then we were changing telephone numbers for that, as needed. There's also, the federal laws that we have to abide by, and the FCC CP&I law currently protects the account holder, including any changes that were made to the account. So the current CP&I law would actually, in my view, and I'm not an expert on law at all, would protect the information of the account, and we would be required to release that information to the account holder. And so I have some concerns about that. And also, I agree with Shannon's testimony about documents, and I'm just not clear on how this would actually make it easier for someone in a quick situation to be able to change a telephone number. And then finally, one thing that is an actual feature of an iPhone, and Guam is like a 80-20 as far as Apple versus Android users, which is very different from worldwide, because worldwide it would be opposite, where there's more Android users than iPhone. But even if you change the telephone number on an iPhone, and let's say that the victim's phone was still being monitored by the account holder, even if the phone number was changed, the SIM number was changed, the Find My iPhone feature would still allow them to track that person's location. And so I would be a bit concerned about that. And so that's it from us. That's really it from us. Thanks so much for the opportunity. And I just want to say for the record that I'm really happy to see that the legislature is raising an issue such as this for the folks in our community. Thank you.
Thank you very much, Ms. Davis. Appreciate your being here and providing that testimony. If we could get it in writing, I would very much appreciate that as well.
Sure.
Thank you. I think that's it for those who've signed up. Is there anyone I missed who wanted to provide testimony on this particular bill? All right. If not, then we will go to questions from the panel. Senator Torres, I would like to begin if you'd like.
Thank you, Madam Speaker. I just wanted to address some of the questions and comments that were made. First of all, to thank the three that came and provided very valuable testimony. I'm going to begin first with a comment made by Attorney Christine Tenorio. We recognize that that not all victims will seek protective orders, and so the bill doesn't require a conviction as one of the things, and it is noted in subsection B, section 30.400. There are things like police reports or protective order, or even an affidavit from a medical provider, court employee, social worker, or advocate. So we understand that there are different tiers. How we address things outside of the protective order once it expires, we'll discuss that further, but we believe that the intention is to include even in any times that there is a threat against a victim. And then, Shannon, I thank you very much for your very good comments and suggestions. We clearly would like to work to further make it easier for victims so that they are not, if the declaration is something that can be signed under the pains of penalty of perjury, that certainly would be something that suffices. Your other suggestion of allowing attorneys or advocates to file for opt-out allowances is something too that we'll take into account. Very good suggestions, and we'll, as we get your written testimony, we'll clearly work to make any amendments or further clarifications in the bill to address those suggestions that you had. And lastly, I just want to comment on Ms. Davis. Thank you for your testimony. And, we are grateful and thankful that companies like GTA have been working and continue to work with victims in these sorts of scenarios. And I think the only comment that I have to that is, the intent of this bill is to expand that so that all companies more or less have that same degree of consciousness and attention to the needs of victims when it comes to breaking away from the contracts or from the main subscribers. And with that, Madam Chair, I believe that was the points that I jotted down briefly through the testimony, and I look forward to the written testimony so that we can further the discussion and make necessary amendments. One amendment that I will be contemplating is that sort of touches on this idea of whether a conviction is necessary in order to avail of this exemption. We are looking at inserting additional language that states that nothing in this bill shall be construed to require a criminal conviction or any other determination of a court in order for conduct to constitute a family violence, as described in 9 GCA Chapter 30.
All right, I look forward to those being submitted to the committee. Or any other additional suggestions that any of you who have testified are willing to submit. We would appreciate those, especially in writing. We did receive in writing the testimony of the Bureau of Women's Affairs this morning, so that should have been provided to all the senators via the drive on this chat. Okay, and so now we'll look to the other senators. Senator Nelson.
Thank you, Madam Speaker. I appreciate the input from all of the attorneys and also Ms. Davis from GTA. That is helpful information. I believe in this bill. I believe it's a very good bill. I believe we just need to focus on how we are going to move forward and address some of the issues that they are concerned about, as far as the accessibility to getting the phone lines removed from the perpetrator. And so I look forward to concrete solutions and any recommendations that you may have as attorneys or those that work in the telecom industry. So thank you very much. Thank you, Madam Speaker.
Thank you, Senator Nelson. Senator Duenas.
Madam Chair. You know what? Certainly, it's a great bill, and I'd like to commend the author. I think some of the most, thank all the attorneys and the legal representations here today to guide us. I think the most compelling testimony came from Bureau of Women's Affairs. Those statistics are just staggering. And it's a reflection of the community. Unfortunately, some illness in our community and things that are happening that we have to take measures such as this and do everything that we can to provide victims the opportunity to escape, their dire situation. So I think it's very clear that this is something that is needed. Of course, and I thank GTA for being here, Ms. Davis. Of course, I think that by and large, most people believe that account holders and the general population of Guam are good citizens operating every day. But these dark situations that victims can find themselves in is really overwhelming. And anything that we can do to allow them to detach from a very terrible, dangerous, and abusive situation is one more thing that a victim has in their hands to be able to free themselves from their terrible situation. So I just wanted to make that comment. It sounds like all the technical stuff is here to address maybe any other issues, and the written testimony should strengthen the bill. And so with that, Madam Speaker, I just want to say Sijuswasi and to Jane, thank you for representing that stark information that really continues to be of concern. So we pray that we can have better results in the future. But for now, let's try to help our victims as much as possible. Sijuswasi.
Sijuswasi, Senator Taitigui, you are recognized.
Sijuswasi, Madam Chair and Speaker, for the opportunity to make it just a few comments. I think the bill it's great intentions. In fact, if I'm not mistaken, S120, the Safe Connection Act of 2021, is being heard in Congress. Actually, has already been voiced in Congress that would actually provide these mechanisms on a federal level, which of course will supersede any law that we put into place. So I know that the US Congress is addressing this situation and may make it a little bit easier for us to follow with all their guidelines, especially when they oversee FCC and certain regulatory departments in that for airwaves. So I appreciate the intent for this, and also look forward to, both on a federal level, it passing on the Safe Connection Act of 2021. And in the meantime, this bill would probably, put into place now before that, because it's always an act of Congress before something gets through. So I appreciate the opportunity, Madam Speaker.
Thank you, Senator Taitigui. Senator Brown, you are recognized.
Thank you, Madam Speaker. I just wanted to ask Ms. Davis if she could just follow up on her comment with regards to the ability to still be able to track the phone, even if the numbers are changed, because I certainly understand the intent of Senator Torres in wanting to help facilitate the ability for someone who's trying to get out of a difficult situation. I think we all understand the value of communication, and certainly for them to want to be in contact with the key people that can assist or make sure their family's okay and things of that nature. But you had mentioned that even if a number had been changed on a phone, that there's still an ability to track that phone. Could you just elaborate a little bit on that? Because most of the rest of us were just used to using the phone with really no idea, what's involved with, like if you lose your phone, someone steals your phone, you can track your phone. So is that something similar with the primary holder? Particularly, we're assuming in this case, it's a male individual that, would be the primary account holder that could still have the ability. Could you just elaborate on that for those of us that are not as well versed with regards to what the technology can do now?
Sure. I mean, that's a great question, Senator. Thank you for it. It's a feature that is meant, 90% of the time to protect you and your equipment. And, the real question in my mind is who set it up on the phone? And I would be worried that if, maybe my partner had given me the phone as a gift, I wouldn't know, because I wouldn't even know to check. And so it is the Find My iPhone feature on your phone. And, as I said earlier, that I would be concerned about that if they were taking the phones with them. And so, I'm not a tech expert. I can certainly add to that what they're changing that all the time. When you see an update on your iPhone, there might be a small tweak and you're accepting and so I would really need to look at the actual tool and what it can and can't do. But my understanding, Senator, would be that unless you had the password to that account, you would, like, if you and I had a shared plan, I would not be able to turn it off without your password.
Yeah, that would be concerning, because certainly if someone's trying to get out of a very difficult situation and then the individual that, is making life difficult for them, if they're able to find them because of the phone, then, our intent of trying to use this as something to help save them can be something that could be a direct way of this individual, the perpetrator, to get directly to a victim. If they have the ability, obviously, to track it. And I guess maybe that's something that we should explore a little further, because I don't know if is there an immediate way that someone, we know we go in and we have to fill in all the application form to get a phone. Is there a shorter way for someone to do it? I know we have the by the minute plan or whatever, and is that an option? What other do you have from your perspective? Is there another way that we could help facilitate so a victim is not attached to any ability of a perpetrator to be able to easily track them down? But is that something, and it would be helpful for the public as well, a more immediate way? Maybe they can get another cheaper phone or something that they can get a hold of, so that they have a means of communicating and not be tied to a phone that a perpetrator can track them on.
Absolutely, Senator. My recommendation today, if a victim came into a retail store or called one of our contact centers, is we would help them disengage from the contract and offer them, as you said, a low-end prepaid phone. I'll be honest, I've also given phones as a gift, as we do with the Rise, and then also given them a prepaid load so that it's completely separate. Right. So there's no worry about tracking. There's no worry about any of their information being shared through any of Google, Teams, or, on the Android side, because we're just talking iPhone here. But there's also, a community of Android users that I'm not quite familiar with as far as tracking. But my recommendation would be to hand them a phone right away with a prepaid load. And this is where I really am an advocate for this Project Rise program, where, it doesn't require any of the paperwork. Goodness, if I was in this situation, just having to do these 3 steps would be very difficult for me. I would likely go to a friend that could maybe help versus trying to get a court order and then, explaining all my information to a health provider. So, yeah.
So at least, is that something the GTA maybe can facilitate, or make more aware? I'm sure with the victim advocacy groups on Guam, certainly the Women's Bureau, and Jane, the work that you're doing there, so that is information readily available, that option can be available, how they can access, or even where these victims will go for assistance. Maybe there's something GTA, bends over backwards in a lot of ways to do community outreach. If there could be a means of facilitating, so that perhaps these individuals, in most cases, we know they're women, most cases they're mothers. I'm sure if they're making a decision to get out of a difficult situation, they probably have angst over that for a long period of time, trying to figure, especially Guam is so small, where do you go and where can you go safely, because they're in a very dangerous situation where it's all about control, and the perpetrator is going to want to bring harm on them. Maybe there's a way they can facilitate so that those that are involved in assisting these victims have a way of just getting the information, or how they can get access to the phone even without them having to go into GTA, for example, at a customer service in an open area, to get a phone, so that they have some sense of comfort that they can communicate freely to who they need to, without worrying, is the perpetrator going to be able to harm them or track them down or keep track of their conversations? Because it's all about control when you get right down to it. So I appreciate that information. I had not been aware. I knew we could use our phone, if it got lost or someone stole it, to track it. But you're right, if it's something that the perpetrator, if they're the primary owner on the account, can also use it to track their victims. I mean, that's frightening, especially if you're trying to get out of a very difficult, and in many cases we've seen on Guam, a deadly situation. So appreciate you responding to that question. And thank you, Madam Speaker, for the opportunity to ask the question. Thank you.
Thank you very much, Senator. Senator Moylan, you're recognized.
Thank you. Thank you, Madam Speaker. Thank you to the panel. The information is very helpful. I think we have more information to strengthen the bill, and any adjustments that may be necessary was very good. And I have a better understanding of the flow and how this should work to protect our victims. So thank you to the sponsor of the bill. And thank you, Madam Speaker.
Thank you very much, Senator Moylan. I'd like to ask those who've testified if they could, if they send in written testimony, be very specific about. So the bill as proposed currently is broader than, for example, the California law. California law, if my understanding, requires a court order, and so this one would allow other types of evidence to be submitted in place of without the need of a court order, including. The list is there. I think police reports, and we've heard that victims advocates should be allowed. I think that's also allowed in the Hawaii statute. So Hawaii statute includes a longer list of entities that can submit that kind of evidence that there's abuse and that these provisions should apply. But if I'm understanding correctly, you are all seem to be consistent in advocating for that. More evidence should be allowed rather than less. Could I ask you again, Chief Deputy Attorney General Taitano, to just confirm that?
Well, in my testimony, I don't know if we were necessarily advocating for more, to add more to the list, but for example, what we suggested is instead of having the victim, which may, they may be reluctant to go to a carrier and submit these documents, that maybe an advocate stand in their place and represent them and be allowed to submit these documents. But we also noted that an affidavit might be a little bit onerous, and because I believe you have to have it notarized. So we thought maybe a declaration would be a sufficient substitute for the affidavit.
All right, so you're saying victims advocate should be added perhaps, and that affidavit will address to remove the notary requirement would be make it easier for the victims. All right, okay, thank you. Attorney Tenorio?
Thank you, Madam Speaker. I just wanted to clarify and thank you to Senator Torres for contemplating the amendment that would say that a conviction would not necessarily be allowed. To clarify my earlier question, it was whether the defendant has to be charged, because the way it's written right now is that, I don't think that a defendant has to be charged, but here's the example I'm talking about. Say someone is arrested for family violence, but that police report has not been forwarded to the AG's office for charging, or they've been given a notice to appear. So there's a police report documenting that they have suffered from family violence, but there have been no formal charges lodged against that defendant. I think that it would help a victim to clarify that if Senator Torres is going to make the amendment to say, this doesn't mean that you have to be formally charged with that, because then what happens is you don't get a criminal order of protection if the case is not charged. But even if you have a police report, you would have to go over to get a civil lawyer to get the civil protection order to get your name off the plan or to get the number changed. Mm-hmm. So I think once that little gray area is defined, I think then it would be easier for a victim to get to avail of the benefits of this law. Thank you.
Right. Thank you very much.
And Senator Tenorio, I totally agree with you. The whole concept here is similar to what we were contemplating when we passed the Safe Housing Act, which was a result of the violence that was occurring with the pandemic, people being locked up and being in closer confines. And the idea there in that act that was passed into law was to make it easier for victims. Similarly, in this case, it is a similar sort of contemplation that we have to allow, certain circumstances to document that there has been violence against the victim, committed. But in terms of a charge, I do not foresee that is one of the criteria that will be required. And so we are working, I will work with you to make sure that is clear, but we want to, we will probably insert language to make it clearer, to put, we'll address that, I guess, in language. I don't have it right now to offer, but your suggestion is well taken. Thank you.
All right, thank you, Ms. Attorney Tenorio. Ms. Davis, do you foresee, GTA is the only company present here today. I really, again, I'm very grateful that you took the time to be here. Do you foresee that any other telecommunications company would have a problem implementing this if it was passed? Well, I mean, you've talked about the
CPNI.
The concerns that would, the disclosure of information that is required by another law. Yes.
The concern that I have, because I would be implementing this on my side, is that currently the systems that we use are really follow the law. And so we're obligated to track your telephone numbers on your account and keep those safe for you for very good reason. And so internally, our processes match that. And so what we would have to do is somehow disconnect that information and figure out how we would report that information to the FCC because this would likely be a CPNI breach, because I'm doing something on your account. If you and I were shared on the same account, that, as I said, our processes follow to protect you and all of the details of your account. And so we'd have to figure out a way to work around that. So as far as, system changes, goodness, sometimes it takes 3 months to change one simple thing. And so I'd have to really talk to someone from our IT department, billing and that and such.
All right. Okay, well, thank you again. I appreciate it. I'm going to now go to the sponsor to close on the bill. Senator Torres.
Thank you, Madam Speaker. Again, I just want to thank everyone for coming out today to speak on behalf of this bill and to offer positive testimony and constructive comments on how it can be better clarified and strengthened for the victims. I want to thank you, Jane Flores, for always being a great advocate for our women and for victims, Christine Tenorio, Shannon Titano, and also Sharon Davis from GTA. We have reached out to other companies. One of the reasons that we were doing this bill as well is we were surveying what was occurring in Guam, and what we found with some companies we didn't find necessary with others. And so the intent was to make sure that we had a law that would be consistent, that can be easily referred to, that can be made available in terms of information for victims, so that everybody understands, what can be afforded to them in dire situations, such as domestic violence and the like. So I just want to thank everyone for their comments, and we'll continue to receive those testimonies and make any necessary amendments to better clarify and shore up this piece of legislation. Thank you also to my many co-sponsors and to you, Speaker Terlaje, for your advocacy and for scheduling this public hearing in due time. I appreciate it. And thank you, everyone. I look forward to continued support on this.
Senator Torres. There being no additional individuals to present testimony, the committee will consider Bill 242-36 LS duly heard. I ask again that if there's any suggestions or recommendations that you have, please put them in writing and submit them to my committee, Senator terlajeguam@gmail.com. The public hearing on Bill 242-36 LS is now adjourned. The time is 9:53 a.m. We will resume at 10 a.m. with a hearing on two other bills.